Hello, and welcome to the Law School Playbook. I'm Hallie Hara, and today's topic is drafting issue statements for your essay exams. Issue statements merely serve the purpose of introducing and framing your essay. So you're going to have a big or a global issue statement that will address the main legal issue asked by the question. And then, as we know, each mini IRAC will have its own mini issue statement. The key is that you don't just repeat the call of the question. Instead, better issue statements tie the legal issue in the problem to specific facts from the problem. So we're going to go over some examples. I have the little warning in the corner because I don't want you to necessarily use this for rule statements, but instead to show how a strong issue statement is drafted. So here we have a short little hypothetical. A bullet struck and injured P when a gun dropped from D's hand during a muscle spasm, discharging the gun. Will P be successful in a lawsuit against D? So where do you start? Hopefully, based on your torts class, you're able to look at this hypothetical and know that the issue here is battery. So we know that in your answer, each element for battery will get its own mini IRAC paragraph. That's how we're going to use the paradigm to organize the answer. So each mini IRAC will start with its own mini issue statement, and the mini issue statement ideally should include rules and facts. So let's look at how that might work. So here, the first element is whether defendant acted. And then we know that the subrule for act is that an act must be a willful volitional movement. And the subrule is really just a definition of what does act mean here. An act must be a willful volitional movement. So when we look at the facts, we say, what fact is relevant to a willful volitional movement? And we say, oh, that's that the defendant dropped a gun during a muscle spasm. So let's compare two different issue statements using that subrule and hopefully some facts. Okay, so the first issue is whether D acted. Okay, so it identifies the subrule, right? The element, not the subrule, it's really just the element that D acted, that's necessary. I don't think that first issue statement is going to get you many points. But compare that to the second one, which says the first issue is whether D performed a willful volitional movement when he dropped the gun. So that second one uses the key words from the subrule and the specific fact that he dropped the gun, right, together to create an issue statement. So that's a stronger issue statement. Let's look at one more example. A DoorDash delivery driver becomes friends with a client who ordered weekly throughout the pandemic. The client is a wealthy woman known for her philanthropy who mentioned support of education. The client encourages driver to attend truck driving school, saying that the tuition would be easy for the client to cover. The cost is $6,500. The driver quits the DoorDash job and enrolls in truck driving school. The client makes an initial payment of $500, but then doesn't pay anything else. The client promises to pay the full tuition, so, the remaining $6,000, after the driver graduates. After graduation, though, the client refuses to pay. Driver and client never signed a contract. If driver sues client, what is the result? Okay, so that's our mini question for our mock exam that we're working through here. So where do you start? So hopefully, based on what you've learned in contracts, you're able to say, well, there's no written contract here. There's no oral contract. Maybe the issue is promissory estoppel, right? Hopefully, you've identified it as such. So we know that each element for promissory estoppel gets its own mini IRAC paragraph, and each mini IRAC starts with its own mini issue statement, which should include rules and facts. Okay, so the first element for promissory estoppel is that the defendant promises something, right? And we know the subrule or the definition is that a promise is a manifestation of an intent to act. That's our definition of promises, our subrule. And we say, okay, what facts are pertinent to that subrule? Well, the client did offer to pay and then again promise to pay when the driver graduates, right? So we're going to compare these two issue statements. The first one is the first issue is whether client made a promise. So yes, it shows that the student knows what the first element is, a promise, but compare that to the second one, which is stronger. The first issue is whether the client manifested an intent to pay the driver's truck driving school tuition. So it uses the subrule for promise, a manifestation of an intent to act, to the relevant facts, the payment of the promise to pay the driver's truck driving school tuition. So the second one is a stronger rule statement. Let's move on to the second element. So the second element talks about actual reliance. So it says that the subrule is that detrimental reliance occurs when the promisee actually relies on the promise. So which fact applies to that? Well, the driver quit the job and enrolls in truck driving school upon client's recommendation and offer to pay. The driver finishes school based on client's promise to pay full tuition when she graduates. So let's again compare two issue statements. The next issue is whether the driver actually relied on the promise. Again, it identifies the subrule at issue, but it doesn't provide the key words from the subrule. The second one includes those key words from the subrule as well as relevant facts. So the second one is the next issue is whether the driver detrimentally relied on client's promise to pay by quitting job and enrolling in truck driving school. So the latter is the stronger one because it applies the specific legal definition to the facts provided in the problem. Here's my final thoughts on issue statements. Don't obsess over them. You can gain a few points. These are the sprinkles on top of the icing on the cake. It's important that you know what the issue is, right? Because that guides the rest of your analysis and the organization of your answer. But you're not going to gain a whole bunch of points by having quote unquote perfect issue statements. The points really live in the application or the analysis on an essay exam. So keep that in mind, give them, that amount of thought, and then also keep in mind that all many issues on an exam are not worthy of equal space and time. So what really drives how you answer a law school essay problem is the call of the question. Does it say, explain whether the act and intent elements are met based on these facts, right? If that's the case, then you only want to focus on the act and the intent elements, and no other elements are going to give you points. However, if you know that the bulk of, the true issue in the case is based on act and intent, but it doesn't give you guidance that you should discuss only those, then you err on the side of discussing them all, but know that those two are are the major issues that's where you're going to dedicate your time and attention, right? So don't devote too much time on a minor issue or a non-issue. There are a minimal amount of points available for those issues. So again, do practice exams, figure out where your time and attention should be spent. So I hope that's helpful. As always, I'm happy to answer any questions. And in the meantime, just do your best and know I'll be rooting for you. Thanks.